Kathy. Wish everyone a good morning or afternoon, as the case may be. This is a topic that is one that has significance for many communities because the whole idea of municipal liability is one that is not extremely old or extremely well developed in terms of the history of American law. So we're going to look at some basic principles that are at work in this liability process. And tree risk is something that has some real significance in the municipal landscape, in part because in many communities, planting trees is a required activity with new development, and maintenance of existing trees can be an important responsibility for those who have legal duties associated either with trees on their own property or trees on adjoining public rights of way. The mere physics of trees can cause a challenge and can prompt us to examine the environment in which trees exist in a very different way. First of all, as you're well aware, trees have substantial mass, and the built environment around them can be influenced by their movement in any way, shape, or form. And then the other habit that we want from trees is generally growth, and that growth can have adverse consequences or produce changes, displacing facilities that we have built. This is often true in the case of utility lines, curbs and gutters that handle drainage, and other structures that find their way into the public right-of-way. The most typical tree-related exposures are either falling parts or whole trees that bring about injuries to persons or property that happen to be in the way, and that can be prompted either by obviously windstorms or by ice, by collisions with trees, any number of intersections between human activity and the existing mass of substantial trees. Another subject in the urban environment that's always a concern is the uplifting movement of tree roots on pedestrian pathways, curb and gutter lines, and other public infrastructure. Often the intent is excellent to plant trees adjoining public rights of way, but oftentimes the result is the power of the tree's root system or the effects of wind can cause tree roots to either uplift sections of pedestrian ways or intrude on utility systems either by their roots for underground systems or by their branches for overhead lines that may become entangled. And then there's always that misplaced planting choice that brings us about a 40-foot tree underneath a 30-foot utility line. And then with modern transportation systems, very often we depend upon unobstructed view of signals, signs, and control devices. And often, even if the trees are not in the right-of-way, branches can grow so that motorists either don't see the devices at all or see them at a time that is later than they would prefer in order to obey the sign, signal, or device. Let's shift a little bit now to the historical foundations of risk. And as I said, this is a relatively new phenomenon. It's not something that has been with us forever. Obviously, risk is the possibility of suffering some kind of loss or harm. If we're engaged in human endeavors, that's inherent in our existence. And the basic rule in the United States that has been imported from the English common laws takes the form of the old mantra, the king can do no wrong. It really didn't mean the king could do no wrong. It meant the king could do wrong with impunity. in many instances. And the rationale for that, the underlying policy foundation, is really a separation or balancing powers among the branches of government to keep courts from being the final source of all government powers. And so if the courts were left in charge of every aspect of wrongdoing, there was a definite shift in power toward the judicial branch. And so the sovereign immunity, or lack of actual ability to sue the government, is kind of the inherent nature of our country's history legally. But in the 1960s and 1970s, American legislatures began to let down the walls and authorize lawsuits by citizens against government, simply because the inequities of not allowing that seemed to create immunities that were unfair and left people with damages that were unrecoverable and harm that seemed unjust. In many instances, when authorization was given to citizens to sue the government, it was done with a number of conditions or limitations, so that certain uniquely governmental activities would be excluded from damage lawsuits, but others would have limitations on procedural requirements for filing claims, and also limitations on damages in terms of actual amounts. The biggest groundswell of this activity was in the 1960s and 1970s. So as I said, this has only been around for the past 40 to 50 years. It's a relatively new phenomenon. So as we go to this risk exposure that governments are now, and I know for most of us, we feel like, well, this has been around forever because it's been around for most of our professional life. But these new standards of identifying how government can be sued in a similar manner to lawsuits against private parties, we get into examining what private parties have to face, and that is avoiding negligent conduct. Negligence is generally defined as failing to meet a reasonable standard of care. But anybody reading that sentence can know that's kind of like setting out a saucer of warm milk for a band of attorneys. A reasonable standard of care, how must it be met, etc. All of these are terms that need a definition, and in a new field of law, that definition has come from a number of places. First of all, there's a duty, and there's a duty for the property owner not to harm others. Secondly, with negligence, there's a breach of that duty. And then it can't just be coincidental, it has to be causative. Did the breach of the duty cause harm or damage? And then ultimately, is that damage? Typically, damages are measured in dollar amounts. There may be equitable causes, but largely here we're talking about causing harm that prompts somebody to make a tort claim and file a damages action seeking to be compensated financially. So there's this duty. Where does it come from? Well, there are a variety of standards, and they're evolving because it is not the traditional historic route that American law has taken. The most common source is state legislation. The duty may be spelled out in general terms, or it may be specific to matters relating to trees. So it's, in either event, state legislation may provide a specific standard of care that is there for everyone to conform to. Additionally, many municipalities engage in what were traditionally called proprietary operations. And in some states, that's still a meaningful term. Proprietary operations were often activities that were, quote, non-governmental, meaning that private parties could also engage in them. Operation of utilities, which can be by municipal utility departments or by regulated public utilities, or otherwise, or the operation of streets, which often combines both the provision of a service and the regulation of conduct on those streets, which would be governmental conduct. In addition to that state legislation, often local governments are responsible for either acting as authorized by state law through local ordinance, or by their home rule powers as established either by statute or constitution, or by their charter, which is authorized as a matter of state law. And these municipal ordinances can establish standards of care, which then in turn yield to setting forth duties. And then a uniform source for every state, irrespective of whether you have state legislation, whether you're engaged in proprietary operations, or whether it's your own ordinances. It's court precedent. And that precedent derives from matters brought before the courts and adjudicated either by judges or reviewed by juries and resulting in jury verdicts. And so the combination of all these factors establishes the quilt of elements of duty that are part of the landscape for a municipal tree risk. So, the plaintiff or claimant in your community has to determine how to make a case for negligence if that person has been injured or harmed, allegedly by somebody's acts or omissions regarding the municipal forest. First of all, it's up to us as actors in the world of public life to know the standard of care, and training opportunities like this webinar, and I'm sure you're going to get a great amount of help from Paul's outline of factors to be considered, can help determine that standard of care. The absence of training or the want of being concerned about or caring about the hazards that might exist can be a breach of duty in itself. Courts may refer to that as conscious ignorance or neglect to inform yourself about your responsibilities. And those responsibilities can be either affirmative. For example, if there's a row of trees along a street, if it's affirmative, you have a duty, and your duty is either spelled out by court decision or by statute or by municipal ordinance, to check those trees periodically to see that they are solid and that they're standing in a way that they will not cause harm or injury to somebody by their failure to be firm and well planted, or they might disrupt the adjoining pedestrian pathway, etc. Or can you simply get by if you remedy things once that hazard is called to your attention? Is notice required? And it's each one of these duties is going to vary from state to state. But the training part is you need to know how those duties play out in your state and whether you have an affirmative or passive responsibility in these matters. Causation is either directly by your actions or indirectly by your failure to act and omission. And in the law, it's seldom, and especially with public agencies, seldom is the causation solely one party's responsibility. So you will find that in some instances, claims are presented against multiple alleged tortfeasors or wrongdoers, and the court is called upon to sort out among those wrongdoers who bears what proportionate share of the responsibility. In general, and not in every state, the liability in public life is generally limited for public agencies to the percentage of the agency's actual fault. And as we said earlier, the damages are usually measured in economic terms. In some states, For example, in the Pacific Northwest, Washington State is one. The maximum damage exposure is essentially unlimited, whereas in other states, such as Idaho, where I practice law generally, the State Tort Claims Act limits damages to $500,000 for any state law-based claim. So different states, different standards, different exposures. Whenever a claim is presented, there are going to be a number of possible defenses that can arise, and those defenses include, first of all, whether or not the public agency met the applicable standard of care. One of the critical elements of that is, what do the records show? It's one thing to have actually done it, but it's absolutely another to make sure that that conduct has been adequately documented. So maintaining proper records of attempting to meet the standard of care is almost as important as meeting it itself. Second, there are often statutory immunities that may protect against liability. For example, in each state's law, there may be provision that says that local governments are only responsible to the extent that their finances allow them to carry out certain duties. And often that protection against liability exposure is vested in the governing board, the city council or the board of county commissioners, board of supervisors, such that they have made conscious decisions on the record that show that they have struck a balance between available resources and their actions. Another possible defense, and we mentioned just shortly ago that there could be multiple defendants, causation by others. Maybe it wasn't the city's sewer department or the city's transportation department, but rather the electric utility or the telephone company that caused the exposure, and it may be their fault in part or in whole. It's important to recognize that as you look at addressing these issues, it's absolutely vital to understand the immunities that are provided in your state's statute. Is there adequate training? Was this foreseeable or not? If trees fall in an ice storm or in a windstorm, how foreseeable would it be, number one, that the ice or the wind would occur, and secondly, has the city or the jurisdiction taken the requisite steps to see that the trees are in a stable condition? All of that can play into how a case is defended. I'm going to close today with just 4 examples of cases that have addressed some of these liability principles in the real world. And you may recognize some of the factual situations here, and we're just going to be able to touch upon them, but I'll quickly go through these. First is a case from Washington State where a standing tree fell across utility lines, brought the utility lines down in the course of a storm, and when a person attempted to move branches, that person was electrocuted. Well, ultimately, the person injured in that instance sued the public agency, alleging that it should have assessed the condition of those trees and not put the person in that position of risk. Operating utility system is a proprietary risk, and failure to inspect all trees in the corridor for vulnerability became an issue for the court to evaluate. The second case is a common occurrence, and this is when foliage from a tree blocks the view of a stop sign, and as a result, someone involved in a traffic crash alleges that failure to keep the tree trimmed was the result of their injuries. And there are different questions here. Was the tree in the right-of-way? Was it on adjoining private property? What factors play into this? The speed limit. How soon should the traffic control sign be seen. You may have policy choices to make. Do you trim back overreaching branches, or do you take the tree out? One makes a recurring task. The other may be good for risk, but damage the community forest. Those are choices to be made. And then finally, two other examples. Trees located at the base of a sledding hill, sledders used the hill and ran into the trees. Ultimately, there was a fatal injury. In this case, a case out of Alaska, it highlights for us the need to know what are the risks of having trees present in those recreational settings, and secondly, when you're defending a case, are there recreational immunity statutes. And then the final case is birch trees next to a sidewalk that led to a tripping accident. This is another Washington case. The power of tree roots to invade the built environment should never be underestimated. And so choice of tree stock, location of facilities, one of the greatest frustrations I think that many people see is the need to keep a walking path absolutely straight instead of giving it a little meander to go around the tree. Always worth considering. So those are just four simple, basic examples of the liability exposure we're talking about. With that, I'll turn it over to Paul.